The justices of the appeals court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice D'Angelo. To my left, Justice Smyth. We will be hearing 5 cases this morning. The rules are, as they always are here, 15 minutes per side with no rebuttal. We have read your briefs with some care, so are familiar with the facts. You may want to just begin with your argument, but that's just a recommendation. The time is yours to do with as you wish. And the first matter we will hear is number 23-187, and this is Commonwealth versus Rodriguez, and we will hear first from Attorney Rotundo.
Good morning. May it please the court. Mr. Dave Rotundo for Mr. Rodriguez. The first issue in this case is whether evidence was sufficient to prove intentional assault and battery. The question is whether Mr. Rodriguez consciously and deliberately intended the contact to occur between his vehicle and the officer's vehicle. Now, the evidence strongly suggests that the defendant was fleeing the scene after he encountered the police. And I'd like to point out, I think it's significant that the officer pulled up to his vehicle and positioned her cruiser within 1 foot of the defendant's vehicle. And further, notably, the officer was not yet out of her vehicle prior to the defendant hitting the vehicle. So, just to summarize it, it's our argument that the contact, the fact that she was so close to his vehicle, was just a byproduct of him trying to get out of the way of the cruiser and trying to escape. And it's inevitable, being so close, that he would make contact.
What if he was trying to escape, but he deliberately ran into the car? Isn't that still an intentional assault and battery?
I think I don't think there's enough evidence to even infer that he deliberately was attempting to make contact. And I think it goes in the opposite direction, where this vehicle was positioned so close to his vehicle.
My point is, though, you mentioned in your brief and just now he was trying to flee. That really is irrelevant to the equation, isn't it? I mean, he could be trying to flee, but if he still hits the car intentionally in trying to flee, that's an intentional assault and battery, isn't it?
I would agree with that, but I don't believe that in this case. I don't think the facts suggest that. And I would look at the Commonwealth versus the Cruzado case and the Garudi case that the Commonwealth cites, and the facts were more persuasive in that the vehicle accelerated when there was the police officer was out of the car holding on to the vehicle. You can infer that it was not merely a byproduct of escape, the contact, but an intentional act to get the person off the car. And again, Garudi, similar facts, overt act of selling the vehicle into the police officers who were surrounding the vehicle. So I'd like to move on to the second issue.
Before you do that, in essence, what you're saying is the defendant hit the car. It was an accident in hitting the assault because he was trying to flee.
Correct.
The judge instructed on an accident, didn't the judge?
Yes.
So that becomes then a question of fact for the jury to decide. If they're given the option that if they find it's an accident, then the defendant's not guilty. So if it's a question of fact, why are we involved?
Well, I don't think there's sufficient facts. That's the Lattimore standard. So moving to the second issue, with regards to whether, again, similar facts, of course, whether it's sufficient to prove malicious destruction of property. Again, as I just argued, that the collision with the officer's vehicle was a byproduct of him attempting to escape, and and there was an explanation. The principal purpose of that resulted in the contact was he was trying to escape. So In this case, in the malicious destruction argument, I would argue that's even, a tougher burden where you have to show that his conduct was motivated by cruelty, hostility, or revenge. And I don't think that the facts at all show that in this case. Again, I'm not going to reiterate my argument that I just made, but there was an explanation for his conduct and that he was trying to flee the scene. That's really all I have. I can refer to my brief or anything else.
I think the obstacle you have is light most favorable, as you've mentioned, any rational trier of fact. And for both of your theories, you're saying he may have tried to escape. But couldn't a rational trier of fact, I mean, it's clear from the record that the reverse in his vehicle worked. That much is clear, right?
That is clear. However, I believe the judge, when he instructed the jury, instructed that they were only to consider the facts of the initial contact between the cruiser and Mr. Rodriguez's vehicle during his attempted escape. But there was a sequence of events where he made contact, and then he made contact again when the officer was trying to corral his vehicle. I think he made contact with a tree and whatnot. So again, he was trying to escape. Was he trying to run the officer's vehicle off the road? I don't think the facts suggest that.
Okay, we have your argument. Thank you very much.
Yep.
We will hear now from Attorney Semmel.
Good morning. May it please the Court. I'm Catherine Semmel for the Commonwealth. With regard to the intentional element, I think it is, as Justice pointed out, a jury question, and it is relevant that he came forward, struck the cruiser, and then when he fled in reverse in the opposite direction, which certainly was sufficient for jurors to find that his driving forward and striking the officer's vehicle was intentional. Made it a jury question. They were properly instructed, and the evidence was ample to support their verdict. With regard to the malicious destruction of property, the first element question disputed by the defense is the willfulness, which is essentially intentional and falls under the same argument. The malice is slightly different because it has to be motivated by hostility, anger, or revenge. And in this case, I think the evidence was also ample, both from his action in driving forward, but I think that's also colored by his actions later when he was resisting arrest with the police, when he wasn't trying to escape because there was no escape, and he was still being very hostile and fighting with the police basically as they were trying to handcuff him. So based on the entire incident, I think jurors could amply infer that he acted with malice in that initial impact as well. I'd be happy to answer any other questions.
Well, you stated anger, but you need to prove more than anger, don't you, for malice?
Well, I think the definition I have is either hostility, cruelty, or revenge. So I think it's probably most clearly fits in my mind under hostility. And some case law we've cited, talks about acrimonious relationships and so forth. So I think that the jury could find that he had some anger towards the police, whether it's because they accosted him or, in the cemetery, or whether it was longstanding. In any event, his actions later demonstrated an anger and hostility toward the police that I think jurors could read into his earlier actions as well.
Is anger the same as hostility?
I don't know. I think it's very close. I think it's very similar. I'm trying to think if any of the cases I cited talked about anger. I don't think they say that specifically, but they talk about, one of the cases, Bailey, which is a 128, talks about an acrimonious relationship.
Well, that makes sense. If you have an acrimonious relationship going in, you can infer that there's acrimony behind this. Let's imagine someone is completely indifferent to these people who are detaining him, in this case, presumably lawfully. He's indifferent to them, but he's got to get out of there. So he hits them and tries to run away. Is that hostility?
I think it could be not hostility, but I think that the jurors could infer that it was hostility.
Beyond a reasonable doubt.
Beyond a reasonable
But
doubt.
we don't know, right? We don't know anything more than these objective facts.
I think that the intentional nature of it, coupled with his actions later, are enough. I think it would be a much closer question if we didn't have his actions after the fact. Thank you very much.
Thank you very much. The case is submitted. Our next case is number 23-589, Commonwealth versus Barry. This is a partially impounded case, so I will trust that you will adhere to whatever the scope of the impoundment order is. And we will hear first from Attorney Merrill.
Good morning. May it please the court. I'm Dale Merrill, representing Mr. Barry. Suppression is a very fact-driven situation. Wrong facts lead to wrong decisions in suppression matters. So it's very important for us to look at what Redcap Gould said in his grand jury minutes, which I've got in volume 4 of the record appendix. He said that an unidentified woman approached to tell him that Mr. Barry was taking photographs of a girl. This is very different than what the Commonwealth asserts in their brief. He did not know who the woman was. And we look at, in volume 4, page 6, lines 9 through 7, volume 4, page 6, 21 through 20, page 7, line 4 through 5, page 10, lines 23 to page 11, lines 4. Redcap Gould makes reference to the fact that he does not know who this woman is, that he's never seen her before, and that he is observing the mother sitting on the bench with the father and the child. So the mother can't be sitting on the bench at the same...
I'm sorry, what difference does this make?
Well, it really goes...
They go over and they see him doing it.
Well, it goes into the issue of, in Massachusetts, we look at the Agnes-Benelli test, two-pronged test of veracity and basis of knowledge. So what we really need to be doing is focusing...
They see him doing it
well, actually,
when they walk over before anyone has said, could you hold up a minute?
Actually, you talk about the police. The police saw an image on his phone. So
they saw him, as I understand it, standing with his camera pointed at the girl and her family, I suppose, while looking a different way in order to be surreptitious, and they saw an image on the phone of the family. I don't know if it was live because the picture hadn't been taken yet, or whether it was a photo, but they saw it before they approached him even.
Right, but what I'm saying is that because of that test, we have no knowledge to know if, in fact, he was taking pictures, but they do see an image on the phone, and...
Look, I think there's reasonable suspicion that he was taking these pictures. The question isn't about was he doing it, right? I thought the question was about whether it's legal or not.
Well, the issue is also that there wasn't anything wrong with him taking pictures in a public setting in the subway. How is this behavior different than any of the thousands of photography students are sent out there to take candid shots in the subway system? That's a very common assignment in a photography course.
It's terribly creepy behavior, however you want to characterize it. The question is it illegal? right?
It's creepy, it's not illegal.
Okay.
And
So, but it is different than someone taking candid shots in a train station. He's focused on this little girl, and he's taking pictures of her, including ones that show her underwear. So it's not nothing.
well, the picture actually shows the entire girl. It doesn't show
That one picture did, yes.
subsequently. But what does he know at that moment before he goes and he calls? That's what really is the important issue.
Pictures of her
Suppression.
underwear may not be illegal either. Maybe you can focus on the reasonable suspicion at the time he's stopped or arrested.
Well, there is no reasonable suspicion at the time of the arrest because, this is a picture of a girl sitting with her phone. We don't even know if it's a picture, an image that's there. Under Robertson, one has to be, if one is dressed and wearing a dress, one is not nude or partially nude for the purposes of the statute. But in addition to that, if we were to look at the other versions of the statute, we need to look at the issue of how a person has to have a reasonable expectation of privacy. We don't have a reasonable expectation of privacy sitting in the middle of an Amtrak station. We are being photographed all the time by all the cameras all around us in the Amtrak station. There's no reasonable suspicion that we're not going to be photographed because we know we are being photographed in the Amtrak station and in basically every other public place around. So under the statute, there was no crime being committed. The issue, though, of it, whether it was the mother or a stranger, does come up because the Commonwealth also argues that they could have had reasonable suspicion of accosting or annoying. But since the little girl and her parents didn't know about it until after the fact, at that moment when it was happening, nobody was being annoyed or accosted. So therefore, there is no reasonable suspicion, probable cause for any criminality. When Officer Nabala arrives, it's important to look at the fact that Mr. Gould says they boxed him in, and those are the exact words that Mr. Gould uses in Record Appendix 4, page 10, 15 through 19. He says that they boxed him in. There was Officer Nabala in a uniform, Santos in a uniform, an unnamed officer in a uniform, and Red Cap Gould, all circling Mr. Barry at that point. Officer Nabala asked him, where are you going? He said, I'm going to my girlfriend's house. And that's where the inquiry really should have stopped, because there was no articulable facts that would say there was any crime that had been committed at that point.
Can I back up a second, counsel? These are very interesting questions, and it seems like this might have been a good motion to suppress. However, the motion judge makes a finding that the counsel didn't file a motion to suppress for strategic reasons. What do we do with that? I mean, again, good argument about whether the motion would be successful or not, but certainly not a slam dunk winner. May have won, but not a slam dunk winner. So how is counsel's strategic decision manifestly unreasonable?
What the attorney said was that it was not a frivolous motion by any means in her affidavit. She said that this particular judge did not allow motions to suppress, and therefore, because this particular judge did not allow it, that did not mean that this shouldn't be something that shouldn't be taken up on interlocutory appeal, because this was a solid issue for a motion to suppress.
But the judge also found, the motion judge, it was strategic because of the minimum mandatory sentence, which he found was dismissed prior to a motion being filed, and it may not have been dismissed if the motion to suppress had been denied. Sounds like a pretty good reason not to file a motion to suppress.
The Commonwealth never makes good offers or offers when they have a slam dunk case.
Well, but the judge found that. So how do we ignore the judge's finding? Are you saying the judge erroneously found that?
Yes, I am. I would argue that, yes.
Well, the plea colloquy, the beginning of plea colloquy says, in consideration of the plea, we're not going forward on count 3, which is the mandatory minimum.
Correct. But you also have to look at Mr. Barry's cognitive ability. And I think one of the things that really highlights it is when he's signing the waiver of going to first
But
appearance.
before the question was, you said that the judge made an error.
Yes.
Doesn't the transcript of the colloquy support the judge's conclusion that there was a consideration by the Commonwealth in exchange for the plea? The literal terms of the colloquy.
I think all of us know that frequently people who are before the court are just going along and saying whatever they're expected to say at that point. They don't really understand. And Mr. Barry had particular issues, having been a person with special needs. We see how when he is faced with the issue of signing the waiver, how he talks about, I'm going to sign this waiver because I want to hurry up and make sure I get out so I can go to work today and I can call my boss. He doesn't understand that by signing that waiver, he is delaying getting out. That is working against the interests that he's articulating. And that's really kind of representative of, what is happening with Mr. Barry. I had Brian Leslie, who is going to come in and talk about how Mr. Barry's will was psychologically coerced. Dr. Drogan was going to come in and talk about that, and his sister was also going to come in and talk about his time that he was over at the Kennedy School, which became the Franciscan School, and about Mr. Barry's limitations. His IQ varied between 67 up to, I think it was 83.
All right, so let's, not obviously, maybe this was waived strategically, but if we assume it wasn't for a minute, what facts are we supposed to use? You're telling me some stuff no fact findings were made about this. Do we view the facts in the grand jury testimony? Do we view them in the light most favorable to you because it's the Commonwealth's burden in the first place? In the light most favorable to the Commonwealth because you're the appellant trying to get it overturned?
Well, actually,
What facts are we supposed to look
pages the
at?
Commonwealth quotes actually support my position. It isn't a matter of the facts in the light best suited to the Commonwealth.
It isn't.
No.
There's been no fact
finding. It's a matter
so-
of what are the facts. And because we had Judge Locke, who was the judge took the plea, and a different judge actually reviewed the motion on the papers and decided not to have the hearing that Judge Locke had ordered, this court is in as good a position as the judge who reviewed the motion to suppress to review it.
Did the lower court counsel ever object to the motion judge not holding an evidentiary hearing? I couldn't find that.
I thought that I had objected to that. I don't see it in the record.
Because I think, to follow up to Justice Rubin's question, all of the stuff regarding his mental health issues are facts that are in an affidavit, but presumably the way the motion judge wrote his decision, he didn't credit it.
Correct.
He did that on the papers, which, as you just said, we can look at it and find the opposite. We can credit it. I mean, isn't that fact-finding by us?
Well, I think that Brian Leslie's has significant amount of information in there. There's all of Mark Barry's school records in there that show his long-term issues. The tests that Dr. Drogan presented showing that Mr. Barry was not malingering, that this was a long-time issue that Mr. Barry had, that he was cognitively impaired as a result of his cerebral palsy. I also think that it's really important to take a look at the issue of the judge misapplying the Berrios case. Berrios has two stops. The first one where the officer just yells at him from the car. The second one when the officer gets out of the car and begins to pursue him. The first was, not considered him being seized. The second one was. In this particular case, we have to look at the fact that Mr. Gould specifically uses the words to say that Mr. Barry was boxed in by the three uniformed officers and himself. And at that point, when he's turning over the phone, Officer Nabala says, I asked for his phone because I knew he would not run at that point. And we all know that our telephones have such personal information on them that we're not about to leave our phone. So by taking their phone, they were seizing Mr. Barry and bringing him to the office. And at that point, they didn't have any reasonable suspicion or probable cause that there was any criminal offense.
Can't the defendant consent to that?
Pardon me?
Couldn't the defendant have consented to that? Didn't seem to be an
Well,
order,
that
give
po-
me your phone. He specifically asked, can I hold your phone?
But at that point, his will is kind of overborne. I mean, this is a very rapidly changing series of events that's occurring. I mean, all of a sudden, 4 people approach you and you're cornered, and one of them asks, where are you going? You tell them, and they're like, oh, give me your phone.
Well,
Okay,
he didn't say that.
will you give me your phone?
Can I hold your phone?
That could be interpreted at that point as being a rhetorical question. If there's no further questions, I'll rest on my brief.
I see none. Thank you very much for your argument. We will hear next from Attorney Slyman.
Good morning, and may it please the Court. ADA Mackenzie Slyman on behalf of the Commonwealth, asking you to affirm Judge Ricciuti's denial of the defendant's motion for new trial. First, I'd like to set the scene here that, again, the defendant's claims in his motion for new trial here are that counsel was ineffective for failing to file these 2 motions to suppress. In order to succeed, he would have to show that those motions would have been successful.
Ms. Slyman, I'm going to hit you right away.
Of course.
Shouldn't there have been an evidentiary hearing in this case when the issues are at least substantial? Not a slam dunk winner, but that's not what the cases say. It's that the defendant raises a substantial issue. These seem substantial. So isn't it an error for the judge not to have held an evidentiary hearing?
No, Your Honor. First, I would point out that the test is not just that the claim raised in the motion is substantial, but in making that determination, the court is looking at the seriousness of the issues raised, which I won't quibble about that here, given that they're standard, but also the adequacy of the defendant's
Was the
showing.
defendant boxed in?
I recognize that that is the testimony of Mr. Gould, however, and I, of course, defer to the court's recollection and review of the transcripts, but my recollection was that it was just Officer Niadbala and Gould, who is indisputably a civilian, who were approaching the defendant and saying, hey, stop for a minute. So
you said we don't need an evidentiary hearing, and I'm saying, was he boxed in? There's testimony he was boxed in. Should we accept that as true?
I want to give you a yes or no answer there, and I struggle to, because Gould was a civilian, characterizing the
It's
interaction in
an
his own
eyewitness
way.
testimony.
I think even if this court credits that the defendant, it's a characterization of movement, so I struggle to say that that in and of itself would be sufficient. But even if the court were to, I don't believe that that would be sufficient to find that there was a seizure that occurred at that point.
When do you say the defendant was stopped or detained or arrested? When did that happen?
Sure. I think the very earliest that the court could put that at here would be when he consents to turning over his phone to Officer Niadbala.
Okay,
because I
so
acknowledge, as
he
counsel
turns
stated,
over his phone, and now he is stopped or arrested, or I don't know what we want to call it. Let's pretend it's a stop, not an arrest, although you've read Royer, I'm sure, and so you know that retaining something of someone's that they need back and then asking them to come with you somewhere, the Supreme Court called that an arrest. But let's say it was a stop. Of what crime was there reasonable suspicion justifying that?
Sure. So the Commonwealth's position is that at that time there was reasonable suspicion of, at minimum, upskirting and, pardon me, annoying and accosting a person of the opposite sex. And
All
I
right,
realize,
let's go. No, you please.
What evidence was there at that moment of upskirting?
Sure, Your Honor. And I'm going to preface my answer by emphasizing, as the jurisprudence is clear, that reasonable suspicion is to confirm or dispel a suspicion of a crime that has occurred is currently occurring, or I think crucially here, is about to occur.
Okay, so
So the-
I want to
Yes.
slow that down piece by piece. The officers, and I'll call them officers, which may be a question of fact I might ask you about in a minute.
Of course.
But there's no evidence that he had a picture of the girl's underwear at that point.
Correct.
There's no evidence that anybody told the officer he was taking pictures of a girl's underwear or undergarments or anything like that. Correct?
I believe you're correct, yes,
So
Your
at
Honor.
that moment, when you just said he was stopped/seized, we know that somebody had gone over and said, there's this man taking pictures of a girl. That's one thing he knew. And he also knew he saw a picture, and again, I'll give it the light most favorable to the Commonwealth, of a girl. Not the family, but of a girl. Where is the upskirting there? Even reasonable suspicion.
Sure, so I recognize that at the time that Gould at least sees the photo on the phone, there hasn't been articulated to him or by his own account a visual of the defendant attempting to take a picture of the 11-year-old's underwear. However, here again, and this is where I emphasize that the reasonable suspicion here can extend to that a crime was about to be committed, and I think what the court looks
Anytime
at.
somebody was taking a picture of a girl, never mind a young girl, a girl in a dress, that's reasonable suspicion of upskirting.
No, I think it's of course it's going to be fact specific, and here
What
the
other
facts here.
What other facts are there that there was upskirting at that point? It was a picture of a young
The
girl.
defendant was intending to upskirt the victim here. I would say that the surreptitious nature of how he's attempting to take these photos by hiding his phone by his side, turning his head in the opposite direction.
Well, he's doing something awfully creepy. The question is it illegal? And we know the answer to that. It's not illegal. There's no one nude or partially nude anywhere in the station, so far as we know.
Up until this point, temporally, I would agree. And
No, ever. There is no one nude or semi-nude, I think that's the phrase, anywhere in the station. These people are all clothed.
Oh, sure, yes, of that instance, not with what the defendant was charged with, because he was charged with possession of child pornography, but.
Ultimately, yes,
Your
but
Honor.
you're saying reasonable suspicion of upskirting. And I don't know why the statute, this particular version of the statute, which has been replaced, I don't know why it was called that, because it's got almost nothing to do with upskirting.
So I would like to respond to that in two ways. One first is that based off of the defendant's mannerisms of taking these photos surreptitiously, trying to look in the other direction, looking like when Officer Niadbala approached him and looked like he was trying to get away and had a guilty expression on him, Commonwealth's position is that supports a reasonable suspicion that the police can then confirm or dispel that the defendant was at minimum, about to attempt to take upskirting photos. And I recognize Your Honor's point of that the statute later in Robertson, the SJC determined that.
Sure, by looking at the plain language of the statute, right?
Yes.
The statute says nude or semi-nude, and a person wearing underwear isn't nude or semi-nude.
Yes, Your Honor, and I recognize that was the focus of the Robertson decision, which again was issued over a year after the defendant entered this guilty plea and waived all non-jurisdictional defects here.
Counsel, I'm giving you the fact that at the time that this happened, the law was unclear. But I'm straining to find where you find upskirting from this. The upskirting cases that I've read about and I remember are from like under a bathroom stall where it's going up skirt. Or in this case, if the defendant was showing a picture way down of a camera trying to go up, that might be reasonable suspicion of upskirting. What we have here is a defendant looking in the opposite direction and taking a picture of a young girl, fully clothed at that point in a dress. I'm not seeing how that could realistically, geographically, geometrically be upskirting based on the testimony of the officers or in the police report.
I understand that, Your Honor, and I recognize we are with the facts we have, though and to pivot for a second and come back to your question, the I know this was asked to my sister, but I think that these facts need to be viewed in the light most favorable to the Commonwealth and the fair inferences that come from those. And I think all of this is always going to be viewed on a spectrum, right? If we were in a situation of a bathroom where defendant's arm is clearly underneath, it'd be a different story. And I recognize this is a harder sell. That being said, in my recollection of the testimony, number one is that the defendant was continuing to do this for a period of time, certainly enough time for that woman to approach Gould, for Gould to come over and see that this is still going on. But secondarily, and again, this is my recollection, but is that the 11-year-old was clinging to her mother, moving around her mother, climbing around her. So from that as well, we can deduce that the defendant was positioning his phone to take advantage of the movements of the victim here.
He was standing up, right?
The defendant, I believe, was standing up, yes, and holding his phone down and away from him in an opposite direction, looking in an opposite direction. And I think the consciousness of guilt factors in here as well, that Officer Niedbala testified that
But
when
doing something creepy can cause consciousness of guilt. It seems like there was no crime at the time, that there was no statute criminalizing this either yet or at all.
So I would disagree with Your Honor that this is, and it's a tightrope I walk here. I would disagree that the statute was not understood to criminalize this behavior.
Because no one read it?
Excuse me?
Because no one read it? How could it have been understood that way? It plainly says nude or semi-nude.
I recognize the plain reading of the statute, Your Honor. I think the fact that this was the shared understanding by the criminal justices in both the police, the courts, that the
Is there evidence of that? Do you have an appellate decision saying that it covered this before Robertson?
No, Your Honor, but I think that can be telling as well, that this statute, by my recollection, was enacted in 2004, and Robertson is the first that this is attacked. That's over 10 years later, and I think, as Your Honor pointed out, the legislature very swiftly acted here to reformulate the statute to be explicitly clear that the behavior here was criminal. But still, at best, or at worst for the Commonwealth here, I think we'd be operating under a mistake of fact by Officer Niedbala, Detective Purcell, by the time they get there, Officer Santos, of if the objectively reasonable understanding of the facts here and whether or not they indicated a criminal act in here, as I stated, where the statute had been interpreted for at least 10 years at that point as criminalizing this behavior.
You have no evidence of how it was interpreted for those 10 years?
Sure, Your Honor. I don't mean to overspeak, but it existed as such for 10 years, undisturbed, until Robertson came along.
Can I ask about voluntariness briefly?
Sure.
This detective says she doesn't think he should go to jail, and she's going to have to go to her supervisor and talk about that. But what he needs is help, because there's some problem with him that needs help. Of course, that's a lie. All of that is a lie. And we have cases saying that you can't tell someone that the court will be more lenient or that the police will be more lenient to them. Why isn't this sort of squarely within that?
Sure, so I'll address that in 3 points. First, just to cover again what Detective Purcell actually said to the defendant, it was that, does a person who's taking photos of young girls just need to get locked up and do prison time? Does that help? I don't know. I don't think that it does.
I don't think that it does.
Sure, so I think that's expressing her personal
I think that's her
opinion.
personal view. Did she stop interviewing him and call to have him sectioned or something?
No, but in her role as a detective of the police, she's not the decision maker, which is further illustrated by her statements.
Whatever.
But,
She says this to the guy. I don't think you should go to jail.
Sure, expressing an opinion. But I think crucially here, all of this portion of this conversation happened after the defendant waived Miranda. So
I'm not talking about Miranda. I'm talking about voluntariness under the 14th Amendment. Right? There's a due process requirement beyond Miranda. that there's certain kinds of trickery the police can't use.
And I would disagree that this extends to being trickery.
How about telling him that if he waives his arraignment, he'll get out sooner? Is that trickery?
I don't think so. I think that that's a much more definitive, a quid pro quo, if you will.
It's a
if
lie.
you do this, you will get
It's
this.
an obvious lie. If they arraign him, he's going to be released in 5 minutes.
Sure, but I think if we had a statement like that here from the detective that said, if you talk to us, I will make sure you get help, I will make sure that you do not get prosecuted for this, I will make sure of X, Y, Z, we would certainly be in a different position, but that's just simply not what was said by the detective to him. She states, you're someone who needs help, and you have a history of doing this, whatever you've been doing clearly isn't working. But there's nothing here to suggest a quid pro quo that the defendant is going to get services in lieu of being charged.
If you stop talking, I'm not going to be able to talk to my sergeant or whoever she says, the DA. You don't think that's saying, so keep talking, and I'll talk to the DA, like I said before, about getting you help.
No, Your Honor, I think that we have not, her statements do not leap that line of creating a quid pro quo that the defendant is incentivized to take, a definitive quid pro quo, that if you speak with me, you will get X, Y, Z.
I think it's what the detective says, not whether he makes a deal or it's called a quid pro quo, right?
Sure. And to that point, Your Honor, I would, when we're talking about the voluntariness of statements, I would pivot to the law here of the totality of the circumstances. When you look at whether the defendant's will here was overborne by anything. And so not only do we have the language explicitly used by the detective, which we may disagree on, but it's Commonwealth's position that it was not offering anything beyond her own opinion of what this defendant was dealing with, but the court, he was, I believe, 48 years old at the time of this plea, at the time of his plea, so 46 or so at the time of the charging, had gone to high school, had held down a steady job for at least 5 years at that
Didn't we
point,
have a
and had experience
factual
with
hearing? Because his IQ is 63.
So I would refer the court back to that, I struggle with the numbers off the top of my head, because there were a number of numbers issued.
63 to 87. 87 is still a very low IQ.
Sure, Your Honor, but that in and of itself is not going to negate any voluntariness of his statement. And I think it's very telling here that the defendant has not attacked his plea colloquy at all, his understanding of what took place there.
Let me ask you sort of about that, and this is more of a procedural question. I apologize. I know your time is up. The plea judge, based on what I read, ordered an evidentiary hearing. He retired, I think, I think we can take judicial notice of that. He retires, and then another judge comes in and says, no evidentiary hearing. Is that okay?
Yes, Your Honor, I would say so.
What about the due deference we're supposed to give to the judge who's the plea judge?
Can you say that one more time? I'm sorry.
Yes. What about the due deference we're supposed to give to the plea judge as opposed to the judge that comes in later? The plea judge says, I took the plea. These issues that I read in the papers warrant an evidentiary hearing. He retires, and then the new judge comes in and basically reverses what the plea judge says. Is that good?
Yes, I think so, and I do not think or certainly it does not amount to an abuse of discretion by Judge Ricciuti and I'll outline a few reasons. First, that though Judge Locke was able to review the filings at that time, the defendant then filed a renewed motion raising these new claims related to his cerebral palsy. So the position has shifted. Secondarily, had there been testimony already collected and provided, and then Judge Ricciuti said, I'm going to disregard that. I don't think I need to consider any of that. We'd be in a different position. And then lastly, and again, this is my recollection from the transcripts, which I believe are either part of the record or in the appendix, that Judge Ricciuti had stated to the parties, we're going to do first an argument, and if I think it's necessary to collect evidence, I will do so, which, again, my recollection is the defendant did not object to that course of action.
We are over time, but it's a complicated case. I want to make sure everyone is okay. Very good.
Thank you for your time.
Thank you both very much for your arguments. The next matter we will hear is number 231253, and this is Commonwealth versus Noge, which I may be mispronouncing. We will hear first from Attorney Cohn.
Good morning. Panel members, and may it please the court. I'm Jeremy Cohn. I represent the appellant, LEONEL Noge. Under prong 1 of Safarian, this trial record shows that no viable defense was presented to this jury.
Can you move the mic a little closer to you? I'm just...
Under prong 2, this trial record shows that an available substantial defense of police witness bias was lost at trial. I wanted to, in my reply brief, I responded to the Commonwealth's points on prong 1. I wanted to quickly make a couple points on prong 1, and if I may, and then go to prong 2. So on the trial counsel gave a closing argument on poor police judgment. So the problem with that was that if the jury agreed that the police officers used poor judgment in deciding to take Mr. Noge under protective custody, handcuff him, transport him to the station, put him in a cell overnight, then the problem is he could still have been guilty of the 2 crimes he was charged with. So both ABPO and resisting arrest.
So would you characterize the closing argument as a nullification argument?
It seems that, I don't know if that's the attorney's, intention, but it did seem that he was saying basically, let's be fair about this. The police officers went beyond the bounds. He was out of step. He really, as a theme, kept reiterating this is a very unusual case. And then at the end of his closing argument, he gives, he points to the jury instructions, mentions the elements of each crime, and then basically asks the jury to find a reason, is essentially what he was saying, find a reason to acquit him because the police went too far. That's not presenting a defense. And I think the Commonwealth doesn't really, I didn't see a dispute or a contention that it was viable. But the Commonwealth did mention 2 defenses, one for each offense. So these other defenses did not come close to being a viable defense at trial. For assault battery on a police officer, the trial attorney in his opening said, he stands up from the couch, he loses his balance, and then that becomes an AVPO. The only time this comes up at trial, this is his opening remarks, and the jury, of course, is instructed that there is, attorney remarks and attorney questions are not evidence. They can't consider that by itself as evidence or as substitute for evidence. So the only other time it comes up is on cross-examination of Officer Ivory, and that cross-examination question said, is it possible, essentially, is it possible that he lost his balance? And the officer responded, no, I don't think so. He was sitting on the couch. The trial counsel drops it there and doesn't pursue it any further, doesn't argue it in closing, doesn't ask any further questions, he doesn't develop it. The problem is that was an unresponsive answer. It couldn't begin to be a defense because there couldn't be any inference from the answer, no, he was sitting on the couch. The push came when he stood up from the couch, and the officer's testimony was, one was like he lunges toward Officer Ivory, pushes, and so that cannot be a defense at trial. The other one is the resisting arrest, and the resisting arrest.
Can you use self-defense in protective custody?
No, of course not.
Really?
Self-defense?
Yeah.
Why
not? Police come to take you into protective custody. You're not under arrest, so you push them away. I don't want to be in protective custody. Get away from me. Can't do that?
Well, I think it's pretty tricky. So if you're correct, I didn't consider that. But
I'm asking, I
either
don't
way-
know.
But either way, the resisting arrest charge, first of all,
Well, no, keep following my train of thought.
Yeah.
Can you use self-defense to defend against unlawful protective custody?
well, the crime of resisting arrest does not allow for.
He's not talking about resisting arrest. He's talking about assault and battery on a police officer. There's
Correct.
no arrest where there's protective custody.
So I'm asking you, because one of the instructions the judge gives, which I think he followed the model instruction, is that the officer has to be performing his duty in a lawful way. So if, and he argues, defense counsel, that the police went too far. So if the police are going too far in placing somebody in protective custody, can a defendant shove an officer away? It's not resisting arrest because he's not under arrest. He's defending himself from protective custody. Sounds like counsel kind of argued that.
Your Honor, I would respectfully disagree with that. I think the problem is that the trial counsel did not argue that. He alluded to these ideas. He certainly alluded to the fact that the police officers were going too far, but he doesn't say that Mr. Noge was defending himself. He doesn't say that he was responding to the idea of an unlawful protective custody. So it's not an argument that's actually made, articulated, or that the jury heard.
So what was the defense you think would have been valid here?
The valid, I think that this is two police officers whose testimony that Mr. Noge committed crimes that evening. The only evidence for that is the word of the two police officers who had the intent.
What's the valid defense, counsel? Are you saying counsel should have just gotten up there and said the police officers were just lying and making this whole thing up?
I think the valid defense, and this is prong two, is police witness bias, that they were biased, that the record is clear. This is the entire defense that I argued in my brief and that I'm arguing now. The entire defense is completely based on the trial transcript. Not much had to be done by trial counsel to put into issue for the jury's consideration police witness bias. The police officers were very open and said that they determined, aimed to put him under custody, take him to detention, put him in jail, handcuff him, and transport him. And that was all determined before there were any crimes.
What is the standard that we have to look for in presenting a defense? Do we have to find that the defense would have been successful, could have been successful? What's our standard here?
Well, you have to find that it was an available substantial defense.
And what is I'm sorry, I was vague in my question. Does substantial mean it would have been successful?
No, not necessarily. It would be for the jury to consider. But there would have to be some basis. If you have two witnesses in any case, let's say not police officers, but two witnesses, it's very common, as I know Your Honor has realized, very, very common, that the entire issue is the credibility of the testimony because there's no other evidence and there is no physical evidence. So I think if an available substantial defense in this case was very much a part of this case, and the unreasonableness of the police officers, trial counsel really embraced that, emphasized it, and but doesn't go, he points to the elements of the charge instead of pointing to the very basic, essential role of the jury to decide on the credibility of witnesses in every case, whether it's an issue or not, whether in this case it wasn't raised by trial counsel. To weigh it's their job to weigh the credibility of the police officers. They can look at their.
But how far, this follow-up to Judge D'Angelo's was, how far could you get by challenging them, by impeaching them as to their bias? The theory would be they're biased, they're aggravated, he wasn't cooperative, so they decided to PC him. Can you get further than that? Can you get that they lied, that he pushed them? Because even if there's bias that they didn't have sufficient grounds to place him in PC, that doesn't justify an assault and battery on a police officer, would it?
I don't believe so. on the other side of the equation? I don't believe so, and I don't honestly know the answer. That's an interesting question. But I don't, again, I think the important fact here is trial counsel did not argue that, didn't come close to arguing it, and did not come close to putting credibility and potential police witness bias up in his argument. I think the way
But before you continue, one of the frustrations is we don't know why. And I know you say the record is sufficient, but we don't know what the record is. We have no facts. For instance, let's say the facts portrayed the defendant in a very negative light, that he said vile, vile things. And, he tested the limits of the First Amendment. That doesn't excuse anything the police did, but it may excuse why counsel doesn't want to go too far down that road, because his defendant may be portrayed in a poor light to the jury. That's a complete hypothetical. We don't know. I mean, why wasn't this before the district court? This is only a year and a half ago. It'd be unlikely for counsel to say, I don't remember. He'd have to remember, right?
I'm sorry, what about the remember?
Why wasn't this a motion before the district court with affidavits from the defendant, from the attorney, et cetera? Because we don't know why he didn't pursue that bias.
Well, this obviously isn't in the trial record, but you may recognize from the docket that the case was stayed. A motion for new trial was pursued unsuccessfully. Not with the necessary cooperation. And I moved to lift the stay, and now we're here.
But you didn't bring an appeal from that denial and consolidate it with the direct appeal?
No, there's no denial, because there was never a motion for new trial because there wasn't the cooperation needed, basically, for attorney affidavit to support it.
But there's also no affidavit that we have saying there was no support. I approached counsel 8 times or 1 time, and they told me to pound sand. And
no, there isn't, Your Honor.
Okay.
Because I do believe, looking at this record, I do believe that the record is sufficient. Not all, and the Commonwealth makes a couple very good points. The Commonwealth pointed to the riskiness of pursuing a defense based on the defendant's, Mr. Noge's behavior, and your point is well taken. So the way I look at this is you can look at the record. I think I agree with trial counsel. This is a really, really unusual case, So the record is clear that the police officers, for some reason, determined before any crime was committed that they wanted to take him into custody. So there's a number of things along, and I think there's different levels of what Your Honor is bringing up, which is the level of bad behavior that Mr. Noge engaged in. I don't think it's extraordinarily bad. I do think he was intoxicated. The intoxicated, according to the transcript, was red, glassy eyes, alcohol odor emanating from his person, from his breath.
Can I ask you about that, counsel? We have cases that say if counsel argues the elements, that the Commonwealth has not met the elements, that's a valid defense, right?
Yes, and I think it is.
So in this case, the end of his closing, he says that the judge is going to instruct you on the elements, and we don't think the Commonwealth has met their burden. The judge instructs on intoxication, and it says that the defendant has to know they're police officers. If you're too intoxicated to know that, then he's not guilty. So why isn't that what the defendant counsel is arguing? He didn't state it specifically, but he says they haven't met their burden as to the elements.
Your Honor, I don't think the jury would get any one juror necessarily would get their mind around that. My point.
So if defense counsel had said he was so drunk he couldn't know the officers were police officers, therefore he's not guilty of assault and battery on a police officer, being that specific would be okay.
Well, if those were the facts, but those are not the facts.
He said they're cops. You're cops. I'm not going to cooperate with you. I've dealt with cops before.
Yes, and I'm responding to the point that he was so intoxicated that influenced what he understood or didn't understand.
Would that have been a valid defense?
Sure, if those were the facts. Those were not the facts. Here, the whole police...
Talking about believing the police officer. That was how you started all this, that the police officer, it's a credibility battle. So just because they said that the defendant said, "You're cops, I'm not going to do this," maybe the jury wasn't going to believe him.
Well, that's true.
I'm just trying to push you, counsel, as to how far we go with inferences here because there was no motion for new trial filed.
Right.
I don't know what his defense was because there's no affidavit, there's no motion for new trial where the judge ruled on. You're saying based on this transcript alone, we can find it. And I'm trying to push you to say, I can find other things.
So the problem in my first part of my response is telling the judge is the one who tells the jury, look, here are the instructions on the elements. Now, trial counsel, fine, he imitated that, gave them the same, nods up and say, we believe he's not guilty. But there's no defense theory. The CPCS manual, clearly it doesn't come even close to presenting a valid defense. Secondly, to respond to both of your questions, the whole police witness bias defense is based on the fact that both officers, and Sergeant Joseph responded because it involved alcohol, so he was going to enforce the policies and procedures that they're supposed to follow. Both officers testified that Mr. Noge was intoxicated. But, so there were that belief supported by facts. The facts were, eye, appearance, and odor. Those were specific facts that supported that conclusion. On the issue of incapacitation.
Your time has expired, so.
Okay.
I just had a follow-up question. I wasn't sure. Were you saying there was a motion for new trial filed?
No, there was not.
Oh, there was not.
Yeah,
Okay.
Basically the stay was lifted, and
There was a stay granted for you to file one. There was never one filed.
yes, there was a stay. We pursued a motion for new trial, no cooperation. The stay was lifted.
At your request?
Yes, that's true.
Okay.
But, Your Honor, may I just make one point?
No. Thank you.
Thank you. Rest on the brief.
Thank you. I think we have your argument. We will hear from Attorney Schillinger.
Morning, Your Honors. May it please the Court, Caleb Schillinger for the Commonwealth. Just to back up for one moment, and the term viable or viability, because where this started, the claim the defendant raised was that trial counsel failed to raise a viable claim, meaning a legally cognizable defense, one that's recognized at law. Now, when I reviewed the transcript, what I discerned was that counsel did do that. I viewed it as counsel on the assault and battery was trying to argue that there was not an intentional touching and as to resisting
Where did he
arrest.
argue that?
So he previewed it for the jury in his opening statement where he says, he has a beer in his hand. Ultimately, this results in a charge of assault and battery on a police officer. And then he does ask Officer Ivory, might he have been having trouble maintaining his balance? There was actually no testimony that the defendant stood up from the couch when he pushed the officer. The testimony was that he was seated on the couch when he touched the officer. So Officer Ivory's response to counsel was not unresponsive, as counsel notes. But that is what I could discern, Your Honor.
Okay, so I've read the closing. It's about as bad as can be, in my view. There's nothing to it. It's insubstantial. He concedes a bunch of points. All right, so he was drunk. They were concerned about his safety, right, which gives away the whole, there was no purpose for this kind of atmosphere that you can imagine someone in this circumstance wanting the jury to focus on. And then he says, we think it went too far, whatever that means, but went too far, why? It seems as though if you believe the testimony, all the elements are met. So it's not too far, and of course they convict. So it seems like a crummy closing to me, even crummier than it had to be if there were no other defense. It's not a good nullification one. It concedes that they were trying to protect him, right? So it's not, and not that you're allowed to argue nullification, but people get it in there, of course. So shouldn't he have argued that if you look at what's available given the evidence, And given that even if the arrest is unlawful, you're not allowed to resist it, and given that there's evidence that he pushed a cop, it's assault and battery on a police officer, isn't the only argument he has that the witnesses are not credible?
No,
He doesn't make that argument.
No, I don't think so, Your Honor. And just to take the first part of your question first, not the closing argument that I probably would have given. Clearly not the closing argument Your Honor would give. And the first time I read it, had the same reaction. Wow, that's really not.
There's nothing
what I
to
would
it.
have
It's
gone with.
insubstantial.
But as I read it again and again, there's a difference here. He is trying, I think, to support the defenses with a theme that the police were excessive or they went beyond the pale with their response. And I think the purpose of that is you can view the undisputed conduct through two different lenses. The police perspective is he meant to push the officer. He did it intentionally. The defense perspective is he was drunk. Maybe
He doesn't
was trying
say
to
in
mean-
closing, he never mentions that. He cross-examines with one question, gets an unhelpful answer. That's all that's in the record.
That's what he can get, Your Honor. I mean,
Well, I agree, but he doesn't even argue it at the end.
I get it. And again, I might have tried to connect the dots, but, it's not what I would have done, what Your Honor would have done. Is it manifestly unreasonable on its face? And I think, it would be better certainly to present this in the context of a motion for new trial, at least so that counsel can explain. what was the
Counsel
strategic
apparently
thinking?
is refusing, I mean, as counsel sometimes do, you're saying they did a constitutionally inadequate job. Sometimes they don't cooperate with making that case.
Well, perhaps, although I've seen many affidavits.
I
where
have too,
counsel
but apparently,
forthrightly
and
admits,
again, we don't have this in the record, but it sounds like not here.
Yeah, well, and I want to be careful not to go too far in terms
Yeah.
of we don't have an
No,
affidavit.
we don't have
on
anything,
that.
yeah.
So I can view his closing differently and, ascribe to it a particular purpose. Was it, especially effective? Perhaps not, but was it manifestly unreasonable? I don't think so either. But
I
as
don't know,
the
it seems to
credibility-
me that, I know, we say reasonable, fallible lawyer, and everyone jumps on fallible, but that doesn't seem, I mean, if you or I hired a lawyer and that was what their closing was going to be, you'd fire them.
I'll pass on that point, Your Honor, if you'll
Counsel,
permit.
can I ask you a question and follow up to what you said earlier?
Yes.
About the excessive use. Let's say that was kind of the defense counsel's argument. I can't find anything that he asked for an excessive use instruction, and I don't think the judge gave such an instruction. And there is such an instruction in the model instructions for the district court. So even if that was a valid defense, doesn't he fall short by not asking for that instruction from the judge?
No, and I don't think that was the defense, Your Honor.
What was the defense?
Again, I think the defense was on those two different charges. One is to the intentional touching as to resisting arrest, that the police were trying to place him in protective custody, not to arrest him. The defendant did not have knowledge that he was being arrested, in part because he was intoxicated.
He didn't argue that either. That also is an argument. The officer is lying when he says, I said under arrest. Did you notice the way he first said, yes, he had told him he was in protective custody, and then the next sentence is not about protective custody. Then he says arrest. Ladies and gentlemen of the jury.
Your Honor, there's no question. You could think of a more effective way to make the argument, but again, the standard is not, is it a closing argument that Clarence Darrow would be proud of?
Well, no, but I'm not, I mean, look, if what I just,
but
spun was
Very good,
Clarence
Your Honor.
Darrow, then, I think we're all in trouble, but.
Right. I do want to address, though, so, the other point, too, is not forfeiting an otherwise available substantial defense, which is prong two of Safarian, and counsel, has raised this idea of going down the road of impeaching the officers. Not only was that not a slam dunk, I think that had the very real potential of backfiring or undermining the defense for a couple of reasons. One is, yes, there was some discussion about why the officers wanted to place him in protective custody, because of course that's part of the narrative here, and it leads to what is the basis for the charges. But the Commonwealth was careful not to go too far down that path because it had minimal relevance. But if the trial counsel opens the door to that and starts really laying into the officers about, well, there was this and you didn't notice this and that, it potentially opens the door for them to explain more why they placed him in protective custody. And one of the
You guys didn't ask.
Correct, we didn't.
Prosecutor could ask. He needed protective custody, you say. How was he a risk to himself?
Well, to a point, Your Honor, because again, it is part of the narrative, but it's not what the case is about, and so you're not going to go down that road. But what I want to point out is that Sergeant Joseph did testify, one of the factors informing their calculus was due to the officer's response there. And if counsel opens the door into, well, really, what's the basis for protective custody here? The officers can testify, perhaps they'll be allowed to testify. The defendant was involved in the violent altercation that led to the officers.
There's no evidence of that at all. Why wouldn't you throw that in? Why wouldn't you charge him with it? Why? They want to put him in a jail cell to punish him? That's not protective custody.
There is no evidence of it in the trial transcript because the Commonwealth didn't get into it because, again, it's not relevant to the charges that are at trial, but you potentially...
Why isn't, to me, it seems like the obvious defense here is, ladies and gentlemen of the jury, you've never heard of a case like this before. Police place in protective custody drunk people stumbling on the street. This is a guy who's where you want a drunk person. In an apartment with the door locked, not behind the wheel of a car or stumbling around, and yet they want to move him to a cell. Isn't that because he had talked back to them? If he's so dangerous, they don't want to take him to a hospital. Is he on the verge of alcohol poisoning? But they say they want to take him in protective custody. Can you believe them when they say that they told him he was under arrest? Can you believe them when they say?
It's too far of a leap, Your Honor. I mean, it's, one, you're assuming you're going to be able to get out, answers that help support this idea of a punitive motive. But two, even if you do, as I point out in my brief, it supports the argument that there's hostility by the defendant toward the police, which, if anything, might lead a jury to conclude, yeah, he really did mean to push Officer Ivory. And yeah, he really was resisting arrest. But why? Because he hates police.
There's no other defense, right?
The point is, right, impeachment is always fraught with strategic considerations, and it's something that counsel has to weigh and consider, and we have nothing in front of us to indicate whether counsel did that. Perhaps if there were a motion for new trial, counsel would say, you know what, didn't even occur to me to ask that or think about it, and then you might have a stronger claim of ineffective assistance. Or perhaps counsel comes back and says, yeah, I thought about that, Your Honor, but I thought it could really backfire, and on the whole decided that it wasn't worth pursuing. And I think that's the point here. I could look at this trial transcript and pick out what I think the defenses were, perhaps didn't do such a good job of making the point in closing argument.
Well, you were telling us what you thought they were. Why don't you tell us what you think the defense was here? At the end of the trial, what was the defense?
The defenses, I think, to each charge were what I outlined or tried to outline in my brief, which was on the assault and battery on a police officer. He didn't intentionally or did not intend to touch the officer. It was an accidental touching. Again, he's drunk, he's stumbling, he reaches out for balance and touches the officer.
And that defense was essentially abandoned after the first question on cross-examination. Might my client have stumbled? Nope.
I don't know, Your Honor. I don't think that it was.
Well, it wasn't raised again, was it?
It wasn't raised through questioning, not that I think that he needed to. Because
was it argued?
Not explicitly, but that doesn't mean he abandoned it. Again, I think he made a strategic decision to focus on the theme of the officers being excessive here because, again, if you buy the idea that they were excessive in their response, instead of viewing the conduct through the police lens, perhaps you view it through the defendant's eyes, which is, I didn't mean to touch the guy, I accidentally touched him. And yeah, you know what? When I got taken to the ground forcibly and had 3 guys jump on top of me, I did what any reasonable person would do. I resisted, I struggled because I had no idea what was going on. Could counsel have done a stronger job of that? Yes, but that in and of itself
doesn't amount to
defense. Well, that's not a defense.
I resisted, I struggled is a confession, not a defense.
Not if the knowledge element is lacking. So, yeah.
No, the knowledge element, I agree, is the critical one.
Correct. And again, what else would you point to here? Everything else was clear and undisputed. They were police officers, as Justice Rubin pointed out. He knew they were police officers. He said, I've dealt with cops before, words to that effect. Mm-hmm. So I think counsel latched on to the elements that he could, which were the mens rea, right, requires inferring something from circumstantial proof. My larger point, Your Honors, which I'll end with, unless obviously there are any other questions, we are all sort of reading the tea leaves and speculating as to what was the strategy here, what was counsel trying to do, and I think that's exactly the reason why this shouldn't be dealt with in the first instance on direct appeal, and it's not indisputably apparent that his strategy, such as it was manifestly unreasonable.
It's one thing to speculate about strategies. entirely another to speculate about what defense was made. I think that's the issue we're wrestling with. I know you've tried to explain, I'm not going to ask you again, but there's a difference.
Understood, Your Honor. Yes. Unless the panel has any other questions, we'll rest on the remaining arguments in our brief.
I see none. Thank you both. Very good arguments.
Thank you.
The case is submitted. We are going to take our traditional mid-morning break. We will return for the final two cases in 10 to 15 minutes.
All rise. Court is open. Please be seated.
Good morning again, everyone. The next matter we have is an impounded matter. It says it's completely impounded, so I'm not even going to say the last name of the party. But it's number 23 P1394, and it's in the matter of the party at issue. And we will be hearing from Attorney Kukier.
Thank you, Your Honor.
And maybe I should tell you before we begin, although there we go. We have talked already substantially about this case in light of all the things surrounding it, many of which we didn't realize were part of this until quite recently. And so we issued an order that I'm sure you got on, I think, Friday. There is a possibility that we will ultimately decide that this needs to be re-briefed and re-argued with people representing different aspects of the case. So with that, you can begin, but I think we're going to have a lot of questions for you about the procedural.
Thank you, Your Honor. I do have the court's order of the 13th, and I do want to address these issues. I am in a curious role here. I started off appointed by Judge Phelan as counsel for JCS. And in that position, my job was to preserve his rights, his autonomy, and his dignity. He did not want his real estate sold, he did not want a guardianship, and he did not want a conservatorship. And that was the position I took for him. In the course of the representation, there were many attorneys who started to represent JCS, and he hired and he fired, and it was cause for concern. Counsel for the then conservator tried to strike the appearance of the attorneys who kept coming in to the picture, and the court, Judge Phelan, retained or appointed, rather, Attorney Tracy Galloway to serve as Zaltman counsel so that there could be a Zaltman hearing on the issue of whether JCS has sufficient mental capacity to meaningfully retain counsel and to fire counsel on his own. In the course of that 4-day hearing, that was nothing short of a 4-day trial, Attorney Galloway and JCS lost the case. The judge decided that JCS lacked capacity and therefore wanted to keep the conservatorship and guardianship in place.
So wait. No party before the judge argued that JCS couldn't hire counsel, but the judge found it anyway. Is that what you're telling me?
No, Attorney Patricia Keene-Martin, on behalf of the conservator, argued that JCS lacked mental capacity to retain counsel.
Now, well, I don't know, maybe there'll be questions about the merits, but I'm trying to sort of get this clear. First of all, JCS, I gather, is not indigent.
He is not indigent.
Therefore, is he paying for all these lawyers?
He was. I'm here pro bono. I am not billing.
Okay, I appreciate that. And the reason you're doing that is what?
I decided to take the case pro bono because I felt that there were so many attorneys involved representing various interests at the trial court level that it would be almost exploitive for me to be billing to do what I'm doing today and in preparation for today's argument.
All right, so.
I ask you a question about that, and I don't usually give prompts, but if you don't feel comfortable answering the question, let us know. The funds that are available to JCS. Can you give me a guidance as to what those funds are?
Yes. So the funds, the source of the funds was real estate. JCS had real estate, and that's the genesis of the entire case. There was a claim that he lacked capacity and that the real estate should be sold. He didn't want it sold. Ultimately, it was sold, and that's the source of the funds.
And was the property sold prior to the Zaltzman hearing?
Yes, it was.
Okay.
This is a single property, the one in which the hoarding apparently took place?
There were multiple properties.
Multiple properties. Is it in the public record what kind of amount we're talking about in total? I don't want you to say it if you shouldn't say it in open court, and I don't want you to say if it's not already in the record somewhere.
I believe it's in the public record, but I would need to check. It's certainly in the probate record, if not the record on appeal.
Okay.
If you find out that it is in the public record, can you file a 16 letter with us, giving us the approximate value of what the estate is at this point?
I know right now what the estate is today. I know how it's held, and I know what it was when the real
No, but
estate was sold.
we're saying, or Judge D'Angelo is saying, don't say it in open court, check and make sure it's in the record, and then, since everything in the case is impounded, if you sent us something in writing, it too would be impounded, and we would know, but it wouldn't be available to the public.
Thank you.
All right, so let me ask you the next series of questions. If it were up to you, who would represent what side in this case? And I also note that, of course, the conservator who took the other side, you're the conservator now. So in some formal way, as the successor to that person, you should be the, appellee. But on the other hand, my sense is that you would not take the or maybe you would take, I have no idea what position you take now that you're conservator.
Thank you. I have given this issue a lot of thought. My belief here is that because in the case below, Patricia Keene Martin was arguing on behalf of the conservator to keep the protective orders in place, and because she prevailed, that she would therefore be the appellee. And because Attorney Galloway
Wait,
and I-
she's a lawyer, not, or was she the conservator?
She was the lawyer representing the
Well,
then-
she can only do something on appeal if her client instructs her.
Correct.
And you're her client now.
I-
Or maybe you fired her and you have a different lawyer, maybe you represent, I don't know.
I was not the then conservator, so she never represented me.
No, I understand,
was
but she
her
would
opponent.
now, because that conservator has been replaced, haven't they?
That's correct,
By you.
by me. So I could potentially retain counsel. I
Yes, but
understand.
you would instruct them not to argue the same thing she argued, because that's not what you think.
Correct. In the case below, I represented JCS in order to look after his dignity, right to be heard, and right to self-determination.
And I should say this on the record, you've done an incredible job, given the position you're in.
Thank you.
Your brief was beyond excellent, and
Thank
it's,
you.
we have nothing but good things to say about your representation.
Thank you. It's an interesting position, but my opinion is that Attorney Galloway and I would be the appellant based on our prior roles as counsel, and that Attorney Keene Martin would be the appellee.
Who hires Attorney King Martin to do that? I assume Attorney King Martin doesn't want to do it for free.
I don't know.
Is there any way that this can be done, that every single lawyer isn't paid for out of that estate? I mean, we have the authority to appoint counsel in civil cases, but I don't know what the scope of that looks like when there are resources to pay for, we don't do it much at all, maybe ever. And obviously in indigent client cases, there are procedures in place, including CPCS, but not if you're not indigent.
In my role as conservator, I would not want Mr. JCS's assets to be billed for the work. He's elderly, he's in assisted living, and we need to preserve these funds, hopefully for the rest of his life.
Counsel, let me ask you again, going back. At the hearing, you said that you represented JSC for dignity, et cetera. Did you represent at that hearing that he had the capacity to hire and fire an attorney?
I did not, because Attorney Galloway was appointed for that carved-out issue.
Okay, so what was your role then? If Galloway sort of stepped into your shoes a little bit, what were you at that hearing?
I assisted Attorney Galloway.
Did, okay.
You didn't file separately a memorandum of law on the question before the...
I did not file anything separately, although I had outstanding petitions to terminate the guardianship and conservatorship, which worked in concert with Attorney Galloway's
Oh, I see.
position.
Let me ask you this. Is it your current position or the current position, well, you're the conservator now. Is it your position that the conservatorship and guardianship should be terminated?
Not at this point, no.
One issue that we always have to reach, is there a case in controversy and mootness? I take it from the fact you were appointed, and I agree with Justice Rubin, have done a remarkable job, that you're well-versed in these issues in the court. Do these kinds of issues regarding the competency for guardianship, for conservatorship, come up frequently?
They do. I hate to say that it is very capable of repetition. I'll give an example. It's not just an issue as to whether or not the incapacitated person or protected person wants counsel to remove the fiduciary. It could come up in a situation where an individual is under guardianship or conservatorship and wants to marry with a prenuptial agreement. How do we know how that individual is going to select counsel, or if they have counsel, or if they have capacity to understand the issue in front of them? Marriage is a basic civil right. People under guardianship and conservatorship can marry. And why wouldn't they be able to retain counsel to assist them with prenuptial planning? Any range of issues could come up. A person under guardianship or conservatorship could aggress and injure somebody and end up with either a civil lawsuit on their hands or a criminal issue on their hands and require counsel. Does that individual have the capacity to retain counsel of their choosing, or even capacity to understand the issue at hand?
Is there any extant party that defends the judgment below? Is there any party, right, I mean, you say Patricia King Martin, but I assume that person is not on retainer for anybody right now.
That's correct.
So is there any party that thinks the judgment below should stand?
I believe at this point in time that the judgment below should stand. I believe at this point that JCS requires a guardian and conservator.
And you think that at the current point, he can't hire counsel?
That is correct. That is my opinion. I will say that in my opinion, the law that was decided is not fully applicable to the facts. I believe there should be more than simple capacity to contract inherent in the decision whether or not an individual...
Now, that seems like a high bar, actually, I would think, particularly given the property rights and, for that matter, right to counsel that people have. But I don't know what the alternatives are exactly, and it doesn't sound like there's anyone whose actual position it is. Now, there are cases I've heard of in other courts, never heard of it here, where someone has been appointed to argue a side. I don't know how that would be paid for, and, there's certainly no reason, if it's not the position of the, does, whatever the, I don't know if he's the appellant or the appellee, JCS, does he have appointed counsel right now?
He does not have appointed counsel. I assist to protect him.
Yeah, I
in my
understand that,
most
but you're
conservative-
you're the conservator.
Right.
He had appointed counsel, but when that case ended,
That was me, and it ended.
I understand you say that was you, but the judge could appoint, after appointing you conservator, the judge could appoint a different lawyer to represent him, and frankly, in terms of deciding if there should be an appeal or whatnot, he might have needed a lawyer. Although, of course, that comes out of his funds.
Did Attorney Galloway or you, because at the time of the hearing you represented JCS, when this appointment or the reporting of the questions were made, did anybody object to your appointment to represent the conservatorship and no one appointing JCS?
At the time that the court made the appointment of me as conservator, Attorney Golden did file an appeal. She was the prior conservator, and she filed an appeal, but it was not precisely related to whether there should be a conservator. She felt that she should have remained conservator, and she took issue with having been removed.
Who represented her?
Don Cordell came in to represent her.
Again, was she still conservator, or now she was as an ex-conservator?
She was ex-conservator.
Who paid for that representation?
That was negotiated down by me, but it was paid by JCS.
He has to pay for someone arguing against his interests.
In the trial below, he paid for many, many lawyers. It really ate up a lot of his assets quite unjustly, but it was what it was. I think there is a simpler way to handle these matters that doesn't require 4 days of hearing, medical evaluations, 5 counsel.
What is that way?
The issue is whether or not an individual has the mental capacity to know that one of their legal interests is at risk, that they've got a legal issue that they need help to resolve. That's what it's about. It's not about contracting. It's not about paying retainers or anything like that. It's about, does an individual understand that they're at legal risk in some way, or that they have a legal interest for which they need representation? And if so, does the individual have the capacity to exercise rational thought process to meaningfully take in information about this legal interest, weigh it around in their minds, understand the ramifications, and make and communicate an informed decision that they need counsel and who that should be. And this is something that can be done with a medical evaluation and a guardian ad litem who communicates and recommends to the judge.
And the appointed counsel would be replaced by this lawyer?
I believe that the GAL could then advise the probate and family court judge whether or not the individual has capacity to retain counsel.
Boy, is this a mess.
Do you think there'd be interest if there were to be an invitation to the community for amicus briefing? Do you think there'd be a lot of interest in that?
Yes, Your Honor. I've considered that. The problem that I don't know how to resolve is that it's an impounded case.
Yeah, but the questions have been reported to us, right? We're going to issue probably a published decision when this is done. I don't see why we can't ask for briefing on, they seem perfectly generic to me. What is the standard for hiring a lawyer? Or what is the standard for firing a lawyer? I mean, that doesn't seem like a secret to So I think maybe we could issue such an order. I mean, obviously, we can lift our own impoundment order to whatever extent is necessary. Do you think the whole case should be impounded?
I'm sorry?
Do you think the whole case should be impounded?
There is a risk if we lift the impoundment because Mr. JCS did find himself subjected to influence and exploitation. He became the subject of a Netflix episode years ago, and that led to an entire lawsuit. And so there is a risk in lifting the impoundment order. His name is known to people.
All right. And who does Attorney Galloway represent now?
Nobody. So Attorney Galloway was appointed specifically for the carved-out issue of the Zaltman hearing.
I see.
And when that concluded, her appointment concluded.
So I take.
You're the only attorney left.
It's
Standing,
me.
so to
I'm
speak.
the only one standing, yes.
Well, maybe this is the way it should have been briefed then. I don't know. And I take it that she's also here pro bono?
Yes.
Okay. Why did it take 4 years to assemble the record?
We tried to appeal, and it sat. The case sat for some reason. We were waiting for, I believe, for the record to go from the probate court to the appellate court. There was a delay in that period of time. We would call periodically just to see what was going on, but it took a while.
But it wasn't through a deliberate decision to, look, we can't do this right now because of the condition of the person or something like that?
Not at all. Not at all. We filed for the appeal and then waited.
At that point, who was the "we"?
I was with Burns and Levinson. It was my colleague and I at Burns and Levinson. We filed for the appeal.
Well, what position were you?
As conservator. So
As
Judge
conservator.
Phelan below asked me to serve as appellant.
Right.
Yes.
I see.
Has JCS's condition changed, I guess, for the worst? Well, no, I'll just say changed since the Zaltman hearing?
Yes, he has aged, and so his position is, he's experienced a aging process and greater diminishment of capacity.
Has, without divulging, I mean, you're the conservator, so technically he's still a client, without divulging attorney-client privilege, has his position legally changed that he would not want to go forward on this appeal? Let's assume he was competent, I guess. Or actually, I don't want to care whether he's competent or not, because that's sort of the whole issue is, has his position changed? At the Zaltman hearing, he clearly took the position that he was capable of hiring and firing his own attorney. Has his position changed?
He's not, at this point, discussing anything like this. It's no longer on his radar.
Okay.
I will say that this is a man who believes that every lawyer is stealing from him. He is so angry.
Only because that's happened.
Thank you. Precisely.
Okay.
Precisely. Without intention. Yes, his assets have been dissipated by lawyer after lawyer, including myself.
And there's no way that you know of that a lawyer could be appointed for him that wouldn't come out of his funds?
Not unless lawyers were generous and chose to
Like
take
you
this
have
pro
been.
bono, which is why the idea of an amici parties would be terrific. It might be done pro bono.
In the 16 letter, which I think you're going to file, I think it might be appropriate if you know of specific committees, boards, whatever, that might be interested in amici for the different parties here, if you could let us know that, it might be helpful.
Thank you. I would be happy to do that. Thank you.
Thank you very much for everything you've done in this.
Thank
you, Your
you.
Honor.
Thank you both.
Thank
Thank you
you
both
all.
for being here, frankly. Anything else, Judge? All right.
Thank you.
Thank you very, very much. I'm going to say the case is submitted. Okay. Because I guess it is. Oh, my God. Our final case for the day is number 23-1318. It is John Doe 244176 versus Sex Offender Registry Board. We will hear first from Attorney Hahn.
Yes, good morning, Your Honors. May it please the Court, Alex Hahn for John Doe. I won't repeat the arguments in the brief, but I do have a couple of things that I wasn't able to address in the brief, in part because I hadn't received theirs yet. I think it's important to drill down on what is the standard for Internet dissemination. It gets a little squishy, and I emphasize this because I don't think respectfully to Brother Counsel, who's one of our best, that they're acknowledging the correct standard. And I think that standard indisputably is Doe 496501, which is 482 Mass 643, Chief Justice Gantz's opinion. That is the core decision on dissemination. And their brief cites another case, which is also an SJC case from a little later that year. And I would say, again, they're respectfully not acknowledging the core of the standard. They're citing a two-part test and also kind of appear to be getting at a totality of the circumstances test. And I would just emphasize that the test is three parts. It's risk of reoffense, level of dangerousness, and efficacy of dissemination. And efficacy is the core issue in this case, and that requires...
Did you file a reply brief?
No, Your Honor. I think perhaps I could have.
I see. I just wanted to make sure I wasn't missing it.
I did
May
not.
continue.
Sometimes, I think this is a case where, in retrospect, I could have. We only have about 14 or 15 days, and I also tend to be not someone that likes reply briefs, but I'm also not trying to sandbag my brother here, and I have no objection to, further briefing or a letter.
If you want to spread the word, we like them.
Okay.
Okay.
Very well. I tend to like less paper.
No, it's
but
not. No, you don't have to file one, of course.
I will begin filing them with regularity, Your Honor, in light of that, where they're necessary. But so it's a three-part test, and the case itself does use the language that there has to be an inquiry into what type of crime would be committed, what type of reoffense, a separate finding, and I don't believe they acknowledge the standard, and I don't believe that standard can be met in this case. I'll come back to that in a moment. I also want to mention that in terms of existing cases, we have Doe 524553, which is 98 Mass App Court 525, Justice Sachs, uses language that I think is important, and I'm not going to claim that sort of a binding opinion in the way that 496519 is, but it's still, I think, an important move forward from that. It uses the phrase "in the nature," an examination of whether an offense in the nature of the index offense would occur. My brother's brief says pretty emphatically that that's not the law. I mean, he essentially quotes, he doesn't put it in quotes, but the same language from that case saying that's not the law. So I think there is, as I see it, sort of an effort to encroach on existing jurisprudence, including that case. The question might come up from Your Honors, what about this always invariably language? The language is from the Doe case, the earlier Doe case I mentioned. Level 2 is almost invariably going to mean dissemination. That language is dicta. It's an observation. It's not part of the holding. And we do have a case, 526105, 100 Mac 1122, unpublished, but Justice Rubin was on the panel, and that's a case where it says that language is dicta. So I think this is a good opportunity, this case, to look at that issue about this.
When an offender somewhat uses the internet in order to do the crime, does that make it more likely that internet dissemination should be used?
It depends what we mean by using the internet, Justice D'Angelo.
Well, let me give you an example.
Yes.
Somebody either has a, I'll use the colloquial term, date rape.
Yes.
Someone kidnaps a person and rapes them. And then the third circumstance would be someone uses an internet dating site, gets the person to go on a date with them using the internet date site, and then rapes them. 3 different scenarios, one using the internet. That's
Yes.
what I mean.
Yes, Your Honor. And the latter scenario is this case, and I don't think dissemination helps us at all with that. And the crime itself is very troubling. There's no indication at all that he used the internet to target this individual. Very respectfully, and I don't mean to be trite about this, but the use of the internet in his case was how pretty much every person who's single uses the internet. And I mean that in all sincerity.
Okay, well then maybe every person who's found to be a level 2 sex offender needs to have publication. Because he met this woman, as I understand it, through the internet, maybe through a dating app? Is that right? They communicated some, he wanted to go out with her, or am I wrong about this?
Well, I cannot see that everyone who uses...
No, but you don't have to. We're talking about this case.
Well, I think that is this case. It wasn't a dating app as such.
What was it?
It was MySpace.
Oy, how old is this
Remember
case?
MySpace? So this was a long time ago. This was in 2007. MySpace was a social network.
Yeah. So it'd be more like Facebook or like
Yeah.
Instagram? Or
Yeah. This is someone he talked to on the phone. They'd kicked messages back and forth. Benign.
But okay, but if you're meeting someone on the internet and it might lead to dating, I mean, dating app seems a clearer case to me. Why wouldn't you want to know that one time on, not a date in this case, but one time with someone he'd met on the internet and wanted to go out with, he had committed serious sexual violence?
So, and I'll get right to the question, but I do think I would go back to, and the SJC has emphasized this, dissemination is very, very harmful. It destroys careers, it destroys lives, so I don't think we can broaden this standard out too far. This man, Doe, is now much older. I think he's probably about 40 at this point. He has 2 kids. He's not doing a lot of dating, at least as we see from this record. So what's the efficacy? When you see this development, because we have to look at these things through the prism of the evidence.
Sure.
And all of the evidence that he put in is dynamic evidence. It's things that are changing and developing. All of Sorb's evidence is static. And the further we get from that offense, the less efficacy there's going to be, the less dangerousness, the less risk of recidivism, Your Honor. So I think we have to look at all of that.
Well, I think your brother counsel said the examiner did look at all of that, and that's why he went from 3 to 2.
So the examiner's language, respectfully, the 3 to 2 is, there's a lot of moving of the goalposts. No earthly scenario would this man be a level 3. So the fact that they were even continuing to pursue a level 3, to me just, is sort of a moving of the goalpost. I hear it all the time, unfortunately, from justices who say, well, if we moved from a 3 to a 2 or a 2 to 1, they're moving the goalposts on that. I'm sorry, I missed the earlier part of the question.
We're talking about dating and the...
So that he considered, there is evidence that there was consideration
yes,
of the
I'm
factors
sorry, Your Honor, yes.
because went from 3 to 2.
Thank you. So the basis for maintaining dissemination is, he says, extra vulnerable people like the victim here. That's pretty much verbatim.
Well,
So
he also cites the internet, though.
excuse me?
He cites the internet in that portion.
No, no. The thing that makes her extra vulnerable is not the internet.
Oh, I'm sorry, I thought you were saying for dissemination.
Dissemination on the internet. I'm sorry, I thought you were going back to the question about the use of the internet. But yeah, absolutely. So he pegs the dissemination to extra vulnerability, not use of the internet. So he is saying, indeed, internet efficacy, extra vulnerability. So we've got to tie those loops together, and the extra vulnerability is the fact that the victim was inebriated and, as was stated, almost asleep. It remains an acquaintance rape. It's egregious for sure, but the extra vulnerability, as we see it in that factor, is not really designed to capture this as I see it. I mean, it's more extra vulnerable people are children, are people with disabilities, maybe elderly people, not this sort of transitory extra vulnerability. So I'll stipulate that it is, but I think it's transitory. I don't think it's the classic form of extra vulnerability.
In your analysis,
Yeah.
when is internet dissemination precluded?
Precluded? I think it's precluded in this case because
I'd like you to speak beyond this case. I gave you a spectrum of 3 different rape scenarios. So unless we're talking about child pornography that is almost always internet use.
Right.
Put that as a side saying, yeah.
Right.
Assuming the other factors are there,
Sure.
internet dissemination there, boom.
Absolutely.
Other than that case, give me the goalposts.
When we have dissemination that would be warranted, Your Honor, let's say this individual had committed a couple of rapes like this. Let's say he had something else in his record, a background of criminality, and I'm not sort of conceding in all cases this would mean dissemination, but absolutely we get different scenarios, not just child abuse. We get people who, A, are committing multiple crimes, B, they're out in public, hiding behind trees and things like that. Those are dissemination cases. Let's say we have one sex crime. Let's say we have this exact sex crime. What gets us to dissemination? To me, a history of criminality, maybe before it, certainly after it, ongoing contact. This guy has had nothing but progress, and he's got police officers in the record recognizing that. So I hope that's sufficient, Justice D'Angelo. I'm wondering if you have any other questions? Or
Continue.
If got just a couple minutes left on the issue of unconscious bias. I wanted to raise this issue because I think it's good to have conversation about it. The letter to the justices and the legal community effectively asks us to consider these issues.
Can I just ask, in this case, we're reviewing de novo the hearing officer's decision, right?
Yes.
So, I am, obviously, if there were bias, there are avenues we can and ought to go down to assure that it doesn't occur again and maybe even punish it. But can we do that in this appeal, since we're not even reviewing the lower court's decision?
You mean you're not reviewing the
anything that the lower court did or concluded or?
Well, my understanding is we would be reviewing Judge Gordon's opinion.
It's an appeal from that, but if it's de novo review, then we're reviewing the hearing examiners.
Yeah. Okay, so if that's the case and you just feel there's no review of Judge Gordon's opinion, then I don't think my argument is directed at the hearing officer. I thought, it was fair to bring this up. The language made me uncomfortable. And I've thought about it more, Your Honors, and I have to say that the stereotyping of black males in sexual matters is a very real problem. That's not something I covered in my brief. It's a very valid concern. And this language that Judge Gordon uses, exploitative impulses, fetishistic prey, it raises concerns. Now, this doesn't mean there's racial bias. I want to be very clear. This is unconscious racial bias. It doesn't have anything to do with racism or intentional discrimination. Far from it. Everyone has unconscious bias. I think it's reasonable to ask if these words on the page get to that. I'm hearing from the court it's not going to be legally relevant. I hope no one begrudges me bringing it up.
That's not necessarily true, and also you should raise it, of course. If you think there's unconscious bias in anything in our justice system, you should always raise it.
Thank you very much, Your Honor. I'll rest on the brief if the panel has no further.
Another question. In the regs, for extra vulnerable victim, it says basically for purpose of Factor 18, the extra vulnerable categorization includes any condition or circumstances. And you've argued that someone asleep isn't really in the middle of that category. Or I don't want to put words in your mouth. You've essentially said that, right? Just because she was asleep doesn't mean she's your classic extra vulnerable. Is that what you were saying?
In essence, I'm going to concede that the word circumstance, you're reading that from the regulation, that would, this would be a circumstance. But I would also say, I'm going to stipulate so that she was extra vulnerable then. I'm not challenging that. I'm saying this is a transitory kind of extra vulnerability that I don't think internet dissemination can be pegged to. I just don't think there's efficacy to another person, a victim like this. What does that mean exactly? He's going to attack someone else who's drunk and nearly asleep? I don't think the record supports that finding.
It's the second time you've said she's intoxicated or drunk. Did the hearing examiner rely on that?
I'm not sure, Your Honor. I think that's a fair question. I think that...
You should know before you claim she was drunk twice, I believe. That's something I think you'd want to have based on the facts.
Yes, Your Honor. I'd go back and look at my brief on that to be sure. And I'm not at all arguing that somehow that sort of diminishes the seriousness of it or anything like that. If anything, I was acknowledging the other way, Your Honor, that if that would be among the factors, the factual elements of this that indicated some degree of extra vulnerability. So
I thought you were saying it potentially to diminish. But if you're saying you're not, then...
No, Your Honor. I apologize to give that inference, not remotely. I was cutting it the other way and acknowledging that this was an individual at the time, in any number of ways, was extra vulnerable at that time. But when the examiner says we need internet to protect other victims like this, I just don't see where we get there that he's going to do this again.
Is that a clear and convincing evidence standard?
Yes. The individual factors can be preponderant.
No, I understand that, but to find internet dissemination, it has to be found necessary by clear and convincing evidence or just by preponderance?
No, my understanding is all of that has to be by clear and convincing.
More questions? Your time has expired. Thank you for a very interesting argument. We will hear now from Attorney Chennai.
Good morning, Your Honors. David Chennai for the board, if it pleases the court. I'm happy to say this is my last physical appearance here until 2025, so I'm going to give it my all.
You had me scared that you were retiring, which I hope you won't do.
I think Doe 496501 was an important case, but it's 496501, and that really focused on the difference between contact sex offending and non-contact sex offending in regards to internet dissemination. I think Doe 23656, which came out 6 months later, is really where the court drilled down on the issue of what is required, and that is that the evidence sustains the classification level, and then you look at the harm that the individual would cause should they reoffend, and to do that, you look at the prior sex offending behavior, which the hearing examiner did in this case. So I think that there's no qualms with the hearing examiner's analysis that the evidence proved beyond a reasonable doubt the internet publication would serve a public safety interest under the circumstances of this case. I think that the hearing examiner did a really good job of drilling down on the which factors were applicable and the weight to give those factors, and acknowledge that the first classification in 2013, when he was made a level 3, he's made lots of progress since then. And that's what caused the hearing examiner to reduce this to a level 2. Now, the question is the hearing examiner's decision unreasonable or beyond the scope of the law? I think under this, in this decision, based on the discretion that we have to give the hearing examiner, I think the hearing examiner did a really good job of balancing all these factors.
Okay, so you and I have spoken several thousand times about the fact that you don't figure out, or at least don't tell us, or anyone, what the percentage risk of reoffense is for low, moderate, and high, right?
Right.
You say you do it holistically, based on expertise. I should let you articulate how you do it without percentages. How do you do it without percentages?
By taking all of the evidence that we get and applying the factors that the board was given to create a whole picture of this individual. Now, this is a good example. When the board made its recommendation of a level 3, they didn't have all the information of the positive strides he's made because that hadn't been put into evidence yet. So the board went in thinking that a level 3 was appropriate on the reclassification. The hearing examiner then listened to all the evidence. For instance, and I think this is pretty much remarkable, he refused sex offender or was terminated from sex offender treatment while incarcerated. He then said in an affidavit that I did do 3 years of sex offender treatment. There's no record submitted, which is required by the individual. But the hearing examiner said, you know what? I'm going to accept the fact that he did do that. And I'm going to give him credit for that.
So let's now look at this case, because I think this case, more than maybe any other I've heard from in a SORB appeal, this case, for me, I think highlights the problem with not telling us what percentages count as moderate, what percentages count as high, and what percentages count as low, you know, using Hansen-like percentages, you know, predictive kinds of things from scientific data. In the critical analytical portion of the opinion, the hearing examiner says, the petitioner sexually assaulted the extrafamilial victim in a public place. Of course, that's true, and you can go further than sexually assaulted. These are rapes. He was convicted of 2 counts of rape, a very serious crime. This is 17 years ago now, in 2007. Everything else is a mitigating circumstance that the hearing examiner uses. I mean, it says minimum contact with the criminal justice system and gives it minimal weight. Let's not kid ourselves. Unlike virtually every case we see, this guy's never committed another crime. No infractions in jail, no crimes, motor vehicle offenses, but no crimes at all. He's been out for 9 years. I know it's not 10, but he's been out for 9 years, and he's never recidivated. He's never reoffended. Not just never reoffended, never broken the law, never, I mean, we see assaults, we see, you know what we see, terrible records. This guy has nothing for 9 years. He's married, he has 2 kids. How can I say that there's clear and convincing evidence of a moderate risk to reoffend rather than low? I mean, I can't predict, I'm not an expert. But he's never reoffended in 17 years, never broke a rule in prison, and never committed a crime in 9 years since. And I'm not saying it's low. You may have data that shows it's moderate. But I don't see clear and convincing evidence that someone who's never done anything else ever is a moderate risk to do something else. So what do you say to that?
What I say to it is twofold. One is, the first answer to that is the fact that the regulations, the majority of them are based on scientific research, which uses statistical analysis in some areas. I think when you read those, and you've seen many of them, these studies, a lot of it's based on statistical data. The second part is, When we first formed the SORB prior to 2005, the first iteration of the SORB was based on statistical numbers. The SJC said that's not going to work. And in 1998, they sent it back and made us develop based on these type of standards so that all of the positive information could come in and the hearing examiner can look at it holistically. That was a decision by the Supreme Court. We didn't have any say over that. And by doing that, we were knocked out of federal funding for under the Megan Act because we weren't following the federal guidelines is if you commit a rape, that's so many points. And they don't really look at the positives. It's basically a grid, and once you hit the grid, that's your number, whether you like it or not. And the state said, the SJC said, no, we're going to have a more expansive review, and that's how we ended up where we are today. Now, again, originally, we tried to follow every other state and the federal guidelines. That was shot down. So we've developed these guidelines, which we are adhere to, and we've been ordered to adhere to.
But how do you get clear and convincing? I understand, look, I've seen ones that are clear and convincing, right? I mean, I've seen ones where the person's already recidivated 3 times, you know what I mean? There's, or these, what are they called? Compulsive and repetitive, right? I mean, we've seen lots of those. This guy hasn't done anything in 17 years. Now, maybe a rape itself 17 years ago means moderate risk to reoffend. I mean, I have no idea what it means because I haven't been given any data. But that's all you got here.
Well, you know.
And actually, with mitigating circumstances.
Right. Well, the beauty of the system that's set up on behalf of the sex offender is we are here today. And you have a right to look at the hearing examiner's decision de novo. And if you don't agree with it, you can say, no, I don't agree with that. It wasn't proved by clear and convincing evidence. You still have to give discretion to the decision, but you don't have to follow it. And I think that in there lies the beauty of the system in the sense that the offender has the right to the levels of appeal.
But I'm guessing.
To review it.
Because you don't tell me, like I said, I don't know, maybe he's a high risk to reoffend. I have no idea. I mean, I've done a bunch of these cases, but that's not expertise of any kind, But I don't see how this is clear. I'm not saying there isn't clear and convincing evidence. I'm not even saying this isn't. But the way it's presented to us, I can't, and I speak only for myself. Clear and convincing evidence is supposed to be not, look, this is an impressionistic decision. Maybe a different examiner would have come to a different conclusion, but this is my conclusion. I'm as trained as anybody else, and that's what I think, but that's not clear and convincing evidence, right? Mine shouldn't differ too much on clear and convincing evidence. It should be clear and convincing.
I must say, Justice Rubin, at this point in our back and forth, you're as much an expert on this as I am when it comes to figuring these things out.
That's very bad news.
I'm given a set of facts, I'm given a decision, and I defend that decision.
Yeah, of course.
And, again, your job as a panel, as a court, is to decide whether or not that decision was properly made. If it was, it should be upheld. If you feel it wasn't, then it's in your prerogative, because you're looking at this de novo, to make that decision. My position and the board's position is that it was a reasonable decision under the circumstances due to the egregious nature of the sex offending behavior. There has been some criminal activity. There hasn't been a whole lot.
Driving with a suspended license.
Yeah, there was 3 or 4 of those in after 2018. I think there was more than one.
I think there were 2, and they also had insurance with them.
Right, but it also shows someone who doesn't necessarily always follow the law, but that's a minimal part of this. I think it's the egregious nature of the sex offending behavior and the hearing examiner's decision or feeling that.
It's all egregious.
Well, some
right?
are.
Well, the ones that are registering as sex offenders have engaged in egregious sexual offenses.
Sadly, I've been doing this so long, I've gotten jaded where sometimes things seem more egregious than others, but the reality is that was, I think the hearing examiner makes that very clear in the decision. how much the impact of that sex offending behavior had on the decision, and then really reflected hard on what mitigating circumstances have arisen since 2013 and reduced it down to a 2.
Yeah, but 3 isn't the baseline. You have to prove it by clear and convincing evidence,
Right.
not that it was a 3 and now it's a 2. You have to actually prove whatever
If it's a
number
2.
it is. Yeah.
And the hearing examiner felt that it's now presently a 2. And again, the board's position states that it was a reasonable decision under the circumstances, well thought out, and not arbitrary and capricious, not in violation of the law, and that it should be upheld. Again, with the caveat, you still hold the power to change that if you want to.
Can we talk a little bit more about the internet dissemination part? What we have here is, and I'll use the language that's in your brief and was also in the decision, almost asleep and confused. That was the victim's state of mind.
Correct.
That offense is the only evidence, as Justice Rubin just pointed out in a different context, that warrants internet dissemination. How? I mean, she didn't give any other reasoning as to why internet dissemination, she said an extra vulnerable victim. So how do we, I guess I'm missing it there.
Well, I think what the hearing examiner was saying that is if, and again, 23656 says you look at the harm that could be caused. And what this individual, what the hearing examiner is saying is that if the circumstance arose and this individual had an extra vulnerable victim situation, that he probably would take advantage of that based on his past sex offending behavior, because you have to look at the past sex offending behavior to
So you
determine
think it
the
really
harm.
comes down to risk of reoffense?
You know,
Like if he weren't going to reoffend, then you wouldn't.
well, no, because the
then you
risk of
wouldn't
reoffense has been.
disseminate.
No, the risk of reoffense has been, in 23656, the risk of reoffense has been factored into, is the level 2 warranted based on the evidence? It then becomes, what is the danger he could pose? Which goes back to 496501, because in that case, the individual, all he did was expose himself to his neighbors. And they were saying, yes, he's probably going to reoffend,
But there's no
what
danger.
danger is he going to cause? In this case, the hearing examiner is saying, yes, if he does reoffend, because we think he might, at least a moderate risk of it, if he does, it's going to be a contact sex offense, possibly against an extra vulnerable victim. But I think the one thing the Superior Court got right, and the hearing examiner was saying, is that still all women could be victims of this individual under the right circumstances.
All victims could be
All
victims.
women that he comes in contact with. He sought this woman out on the internet. She found out he was dating her cousin while he was trying to set up a date with her. Happened to run into each other at this party. She goes down to sleep. He goes into the bedroom with his girlfriend and then early in the morning leaves the girlfriend's bed and comes and rapes her.
Does it matter that he's married?
That may be or may be not helpful because we don't know.
Maybe he's dating less now that he's married.
We assume so, but we didn't actually have letters of support from the wife.
Okay, but you have the burden of proof.
We have a burden of proof of proving risk and danger. He has a burden of proof of showing the mitigating circumstances. If he's married, that may reduce it, but all we have is information he was married. I know a lot of people who are in not so healthy a marriage. So unless we had some information from the wife as to the status of their relationship or marriage, I don't know that the hearing examiner needed to consider that.
So internet dissemination protects extra vulnerable victims that are almost asleep and confused.
Internet dissemination protects any possible victim based on an offender's prior behavior. And once it's established that he is, say in this case, a level 2 sex offender, and that he has the possibility or the harm that he would cause would be a contact sex offense against a woman. It doesn't have to be an extra vulnerable woman, but that he could cause a contact sex offense of a certain nature, then I think that at that point, internet dissemination is warranted.
Does it matter that the hearing examiner said it was to protect extra vulnerable victims?
I think that's a overstatement by the hearing examiner. I don't think that limiting it that way, I think once you show that there's a risk to reoffend at a level 2 and that the harm that can be caused based on what happened to this woman, I think that's sufficient in and of itself. I think the hearing examiner was trying to also emphasize in this case that the victim was extra vulnerable.
The issue I'm having with your language is that, and maybe this should be the case, anytime there's a contact offense and the person's level 2, there should always be dissemination. That's how I'm reading what you're saying. And I don't know if that's the law. Because in this case, you just said, take out the fact that it's an extra vulnerable victim. That's not really important. It's a contact offense, level 2, because we've already found risk of offense. There should be automatic internet dissemination, and I don't think that's what...
No, I guess that's not what I'm trying to say. What I'm saying is that if you look at the type of contact sex offense it was and the harm that it caused, such as if you have someone who repeatedly sexually offends 1 or 2 individuals, he's more likely to be a 3, and internet dissemination would be required. If it's someone who indecently touched a child or an adult and 10 years have gone by and that's the only thing they've done, well, maybe at that point a 2 or 3 is not warranted and internet dissemination is not warranted. It's based on the level of harm that's caused by the actual touching or the actual sex offense. Again, going from the premise of 496501, non-contact sex offenders generally don't pose the same level of harm upon reoffense as a contact sex offender.
I mean, my recollection now that I heard you talking about the case, it wasn't a mere non-contact offense, right? That's the one where the guy takes a picture of his hand on the doorknob of her apartment and inside her elevator or something. So there's some kind of threat of physical contact.
So there was just a decision issued by a panel this past week that basically said if an individual has a history of non-contact sex offending, but their behavior is escalating to a level where it's reasonable to presume he is on the verge of or could commit a contact sex offense, a higher classification is warranted. And it's one of the few cases that I've actually succeeded in on that issue, so I had to bring it up if I could get it in.
So the risk of reoffense lowers substantially after 10 years, and he was just short of that before the decision, but he's past that now. When is he entitled to another hearing? Or has he had one?
February of 2022, he can
3 years?
apply, or 2025, he can apply for a reclassification, so in 2 months.
Same burden. Is this a reclassification or is
This is
it?
a reclassification.
Okay. Anything else? All right, I see no further questions. Thank you both very much.
Thank you.
For your arguments.
And
With that, our business is concluded. So I'd like to thank the court officers and the court staff for their assistance, and we stand in recess.
hope to see you in 2025.
Yes, have happy holidays, everyone.